A child's birth parents usually have custody of a child and make everyday decisions about a child's care and safety. If parents cannot care for a child, the Massachusetts court can give the care and custody of a child to another person called a guardian, or two persons as co-guardians. A guardian takes on the role similar to a parent and provides a stable home and care. A minor is a child under the age of 18. There are some important things to know before you start a legal process for guardianship. It is helpful to know, when can the court appoint a guardian? The court looks at the legal rights of both parents, even if one parent is not involved in the child's life. The court can appoint a guardian when the parents have died or are incapacitated, or when parents give their written consent to the guardianship by signing a notarized waiver and consent form in front of a notary public, or without parent written consent if the court finds the parent is unavailable or unfit to care for the child. If the Department of Children and Family has custody of the child, check to see if the probate and family court or the juvenile court may appoint a guardian. Talk to the child's social worker about becoming a guardian through the Department of Children and Family case. Who can be a guardian? A guardian can be a grandparent, an adult sister or brother, a relative or a friend, or anyone interested in the well-being of a child. The court may request a criminal and Department of Children and Family background check of the adult asking to be appointed guardian. An adult may not be considered appropriate to be a child's guardian if there is a current investigation or charges pending for serious bodily injury or neglect of the child. What are a child's legal rights in the guardianship process? A child under the age of 18 has a right to be represented by a lawyer in a guardianship process. A child or anyone who cares about the child can ask the court to appoint a lawyer to look out for the child's best interests. If a child is 14 years old or older, he or she has a say in this legal process and can suggest a person to be guardian or object to someone asking to be appointed guardian. The child must give written consent to the guardianship by signing a consent form in front of a notary public and can ask to attend any court hearing. Do you need a lawyer to become a guardian? No. An adult does not need a lawyer in order to ask the court to appoint a guardian, but it is often best to speak with a lawyer before filing court papers. For legal help, ask the staff at the registry office of the probate and family court if they have a lawyer for the day program or a family guardianship clinic where volunteer lawyers can help answer your questions or assist with court forms. Contact a legal aid program in your area, and if you are low income, ask if you are eligible for free legal help. Hire a lawyer to help with your whole case, or hire a limited assistance representation lawyer who can assist you with part of your case and you agree to do the other parts of the case yourself. This can sometimes make legal help more affordable. If guardianship is best for a child, the legal process to become a guardian can be broken down into about 4 steps. There may be more steps or different steps depending on your situation and if you are asking for a temporary or permanent guardianship. It's important to always check with the staff at the registry office of the probate and family court to help you identify the steps in your case. To become a guardian, Step 1. Fill out and file the guardianship court forms. Step 2. Let others know you are asking the court to appoint a guardian by giving them notice. Step 3. File proof that notice was given. And Step 4. Attend the court hearing. Let's look at each of these steps. Step 1 is to fill out a petition for appointment of guardian of minor and other court forms. The other court forms you must file with the petition are listed on the help page. The forms can also be found online on the court's website or at the probate and family court in your county. You must file or give the forms to the staff at the registry office in the county where the child lives. You may file a petition for guardianship in either juvenile or district court if there is an ongoing case there. What is a temporary guardianship? If you have an emergency and a child needs a guardian appointed right away to avoid a harmful situation, ask the staff at the registry about a temporary guardianship. A guardian can be appointed for up to 90 days while the steps to obtain a permanent guardianship are completed. In step 2, you let other people know you are asking the court to appoint a guardian by giving notice. After you file the petition for guardian of a minor, the court will send you a form called a notice and order, which contains the hearing date, how to respond or object to the guardianship petition, and more information. Give a copy of the notice and order and the petition for guardianship to others who have an interest in this child. Who must get notice? Certain people must get the notice and order before the judge can appoint a guardian. Follow the notice rules, which tell you who gets notice, how to give or deliver it, and by what date. Read more about the notice rules on the help page on the Massachusetts Guardianship Association's website. Once you send notice according to the notice rules, you file proof with the court that you gave notice to all the interested people. Fill out and file with the registry a return of service court form. It tells the court that notice was given. Check with the staff at the registry to see if all other court forms have been filed for the hearing and if anyone has objected to the guardianship in writing. Step 4 is attending the guardianship hearing. Go to court on the day and time of your hearing. The probation officer will request a criminal and Department of Children and Family background check for the person asking to be guardian. After that is complete, you will go to the courtroom where the judge will review the case. If notice was given to others and there is an appropriate guardian, and it is in the child's best interest to appoint that guardian, the judge can grant the guardianship. The judge will issue a court order appointing a guardian. The help page has more information on all the topics in this web video. Go to the Massachusetts Guardianship Association's website at www.massguardianshipassociation.com. What happens after the court appoints a guardian? Go to Part 3 to find out more about a guardian's responsibilities.